This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and Court Rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because his phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself. If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone experts on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 406.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And you can testify to that.
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration. Now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on and 5, whatever it was, 4, so whatever it was,
448.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify. That's it.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well,
it's that,
why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness,
yes, sir,
or the alibi instruction likely is not going to be given.
yes, sir.
If they come across evidence that supports an alibi, is their obligation to immediately make you and the court aware of it? And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.